So we're just going live. Hello everyone, I'm Sylvie on the social media team here at Invoice to Go, and I'm joined again today by Susan Burns, who is our resident lawyer and expert in all business law. And today we're actually talking about the trademark basics that you need to know as a small business owner. So all about trademarks, copyright, service marks, and intellectual property. I think this is going to be a really interesting presentation and a guide by Susan. So I know that there might be a few questions from you guys, and there'll be lots of time at the end for Susan to answer those questions. So feel free to comment whenever you have a question in the comment box, and we'll get to your question at the end of the presentation. And if you aren't watching this live, you're watching this back as a replay, then please feel free to comment as well, because we'll be checking the comments and getting back to you when we can. So awesome, thank you. Susan, do you want to take it from here and introduce us to trademarks?
Sure. So I'm delighted to be here. Thank you, Sylvie, and thank you, Invoice to Go. What a remarkable service they offer for you to provide this information and all the other things they've been promoting, the programs they do. Great service. Very impressive company. So I'm really happy to be here with you. And today, as Sylvie said, we're talking about trademarks. And so we're going to go through the basics of things that you need to know about trademarks. And just a little bit about me. I've been a lawyer for a lot of time, a few decades. And Sylvie, you're going to will you send the PowerPoint out afterwards or no? Or do they have access to this?
Yeah,
so,
we can do that.
Okay, so just so you see in my bio here, and I'm looking off to the side because I have a split screen and I put it on the wrong screen. So anyway, that's why I'm looking off to the side. But so you'll see on my bio, there's, click here. You can click on those when you receive it. But it gives you a little bit about my professional speaker bio and legal credentials and education. And so what I like to do is work with companies to either prevent the problems. I'm also really clever at helping you get out of a mess, but I like to get with you before you get in the mess and to, help you use legal to make your business more profitable. And I don't think people think about legal in that vein very much, but it really does help your business. It helps your professionalism, and it really helps you grow. And by learning more about legal, you make yourself less vulnerable, and you have a little more savvy. So I think it's a very good thing. I will add one note of caution just for Invoice to Go and for me. This is general information. This isn't specific legal advice for you in your business. You do need to consult with an attorney on your specific areas. And a lot of people ask about, oh, well, can you give me a template or can I do it myself? And my answer is no, don't do that. It's a very specialized profession, and we study hard and gain experience for a lot of reasons. So you should really retain an attorney. Business owners, I think, always should have a relationship with at least one, maybe more attorneys that they like to work with. So trademarks and service marks, there's sort of one and the same, but everybody talks about trademarks, and they fall under the umbrella of what we call intellectual property. And so generally we talk about three areas: trademarks, copyrights, and patents. So we're not going to talk about patents or copyrights really today, but patents they're what's called hard intellectual property, and it consists of engineering and designs, usually sciences or mathematics, or there's things that are more complex than I've ever studied. Most patent lawyers have a science degree as well. And so copyright and trademark are called soft intellectual property, and there's a lot of confusion between the different kinds of these. There's trademarks, trade secrets, trade names, service marks, copyrights. So I'll just say that a trade name is the name that you use for your business. So the name of my legal entity for my business is Susan Burns LLC. And if I did business as best lawyer in the world, that would be my trade name. Okay. So whatever, you can have a business name, but whatever you use for people to know your business out in the world, that's your trade name. Now, trademarks and service marks, those are the same kind of thing, and I'm going to help you define that in just a second here. But one is for goods and services, or for specific goods is a trademark, and a service mark is if you brand your service. So if I did legally savvy services, the legally savvy part would be a trademark. So it's but when I talk about trademarks and service marks, that's basically the same thing. They're just for different products. One's a product, one's a service. So it identifies and distinguishes the source of goods. So when you think about, well-known global brands, like for example, Coca-Cola or Kentucky Fried Chicken. I mean, Coca-Cola is one of the easiest, like most highly distinguishable logo. That even when you see that scrolly C of the first letter of their logo, you know what company that is, and it's always red, right? Or most often. So that identifies the source of that Coca-Cola is from the Coca-Cola company. And it helps you establish that this is a consistent product, it's the quality, all those kinds of things. So when you open a can or a bottle of Coke and you take a sip, you know exactly what that's going to taste like. There are no surprises. Now, if I made some, added some caramel coloring to soda water and bottled it and used their logo, people would drink that and they'd go, hey, what's the matter with Coke? They're not making their product how they should. And the quality is really going down. And so that's why you want to, when you brand and you register your trademark or service mark, you really want to police it. You don't want people using it. But so the slide that we're looking at here talks about establishing rights in your mark based on use, and that's called common law rights. So if you're using a particular trademark in a service area, like in your state, you're known Betty's Pies, and everybody knows what that logo looks like. But somebody else comes along and makes a national or a global brand, and they trademark Betty's Pies and they register with the Federal Register. They have the right to use that, and that right is superior to yours, except for in your area that you've already established it. You have what's known as a common law right to use it in your market. You do want to register, though, if you have a business of any size or you plan to grow your business, because it gives you additional benefits. If you don't register and you just use the name and establish your trademark, that way you cannot initiate a lawsuit about it. You just have to say, look, here's my common law. I mean, for your common law, but you can't go after somebody for using it federally, if that makes sense. I hope that makes sense. Was that clear, Sylvie? It's kind of a complicated topic.
Yeah, that's clear. Sorry, I was on mute.
Yeah. Okay,
Yeah.
good. Yeah, so what can we trademark? It has to be non-offensive. It can't be generic. I can't trademark the word food, for example. You can't co-opt, and you can trademark a symbol. It can't be something that's already registered that's confusingly similar. I think Coca-Cola is so well known that if I tried to register that for anything else. I don't think it would fly, but let's say Betty's Pies. I'm trying to think of an example using that where it would be not confusingly similar and would be appropriate. Well, let's say Betty's Ties, and you know, makes ties, but uses the same sort of styling as you. I think they could probably get away with it because it's not a similar product. A tie is not a pie. But even so, there are a lot of nuances here, but I'm just trying to give you an idea of what this means. You can't trademark a generic word, like I said, food. You can't trademark Apple for apples, but we all know Apple computer and phone was able to trademark Apple in connection with electronics, because that's a sort of a fancy, non-expected use of the word Apple.
I have a question,
So it's
Susan.
not generic.
Yes.
Yes.
If you had a business that you wanted to trademark and it was like a name, or the name that you had, and say there was another company that had a similar name or the same name, but they were in a different industry, how is it decided whether that industry is similar or not? Like, who makes that decision on whether or not you can have the trademark?
Yeah, well, that's done in connection with the examiner in the trademark office. And of course, you have rights to appeal if they deny your trademark and you think you have a strong case, you can take it to court.
And is that then internationally recognized when you have a trademark?
No, you have to take further steps you can make it internationally recognized, but you have to take further steps to do that.
Okay.
Just registering it with the U.S. Patent and Trademark Office, that's the first step. And then there's the Geneva Convention and all kinds of other things. World Intellectual Property Organization has standards that you want to adhere to for registering and protecting your trademark. So, and the strongest trademarks and your highest chance of success in registering is a fanciful trademark, like you see the examples here, Xerox or Kodak. But Xerox is an interesting one because they didn't police the mark. And I can't remember what the outcome of that case was, but people said, look, because a lot of people started saying, will you Xerox this for me? Instead, what they meant was, will you copy? But so when it becomes a common use term, then it's no longer protected. So once you register, you really do have to be diligent about making sure that you police your trademark and how it's used. So in here, I have an example of Service Marks, Flourish Yoga Studios, or Router Plumbers, Nike running shoe, Apple computer. Those are physical objects for trademarks. And a lot, as I said before, we use trademark for trademark and service mark. So in the United States, what we do is we register with the United States Patent and Trademark Office, and that's done by completing an application. I know that some people do that on their own, but there are some nuances because you have to register your trademark for each class of goods or services that you're using. And that means, like, if I want to use Betty's Pies, so I'm going to use that for the pies, obviously, but if I also want to use it on baseball caps and t-shirts and napkins and other things, and maybe I'm going to sell things, then in order to protect the trademark for use on that, I have to include that class. And there's an art to, sort of predicting what you shouldn't do for registering per class. And also, sometimes because you have to pay a fee per class, and I'll get into what those fees are in a minute, but there's somewhat of an art to working to combine so that you have enough classes, but not too many, so you don't have to pay through the nose for it or pay more than you would otherwise have to. So your benefits of federally registering your mark are it gives constructive notice to the public that you're saying, hey, this is mine. And I have a trick for you. If I forget, remind me to tell you that you should do even before you register. And it gives you the exclusive right to use that mark nationwide. And you also have the ability to bring an action in federal court to protect it. And then you can use it as the basis to register in foreign countries. And so those are the important reasons to do it. If you're serious about your business, I think in growing your business, you should register to protect. The process can take quite a while, and it depends on how it goes. So the first pre-application, you want to do a search, and your lawyer will do that. But before you talk to your lawyer, I think it's a good idea just to do your own like Google searches and search what's out there. You can also, and I give you the link of the Patent and Trademark Office at the end here. And so you can also go on there and do your own search in their database. But I think you want to do that, but then you also want to have a professional conduct a search and then advise you on the likelihood of success in your registration, because every trademark registration goes through an examination process by attorneys who are hired by the USPTO, and that is all they do is review trademarks and decide who gets them and who doesn't. So you have to, of course, pay the correct fee. You have to have the correct classifications, the class identifications that I was talking about before, base bell, caps, key chains, menus, those kinds of things, and what your basis of filing is. And then you also have to provide a specimen of the trademark. So you have to, show what it looks like. And there are a couple of different kinds, I'll get into that, but a couple of ways that you can do that. So then what happens is you file it, and then they send you a notice that says, yeah, we have it. Let us take a look at it. And then usually 2 to 4 months, and I haven't filed one during the pandemic, but I am imagining that the periods are extended now because of all the disruption in the work from home. But then they'll send you an email and say, oh, there's a problem here. We don't like this, that, or the other thing, or the way it's used in this application isn't quite right. You try to head that off at the pass. You prefer not to have that happen. But so usually if you filed properly, you can meet whatever objection they might have. And then you publish that mark. The trademark office does what they call publish for opposition. So they say, we've looked at this, we think it's good to go. But if you object, anybody out there, you public, object to the use of this, let us know. And then if they object, then if somebody says, no, you can't file that because of this reason, or I've used it here, or it's confusingly similar in this way, then you have to kind of fight it out. I have on my website in the blog post, on the blog page, there's a blog post about Cat and Cloud Coffee and Caterpillar, the company, the big cat maker, the yellow cat. Cat and Cloud filed for a trademark, and Caterpillar went after them. Now, I mean, you think that's a slam dunk that they're not confusingly similar at all, which I still think it's a slam dunk. Anyway, I think they finally settled it, but they were going at it for quite a while. So just because you think it's not going to raise an objection doesn't mean it won't. And just because like to most people looking at it, you go, no, that's not confusingly similar, doesn't mean that somebody, and especially a big company, isn't going to go after it. And what they seem to have developed a pattern of going after smaller companies that were trying to register any trademark with the use of the word cat, which isn't an attractive look, I don't think. But anyway, so it can all happen.
So do their lawyers sit on the trademarks website and wait for new trademarks to come in? And is that how they
They have
find
lawyers
out?
in the company. Yes, they do research every day for new
Wow.
filings or new trademarks that are published for opposition. Yes, they do.
Waiting to
They
pounce.
also, yep, just waiting. The cat. Yeah. Oh, so, but if nobody opposes the registration, which is the more typical process, then it's allowed. You get a notice of allowance and you get a fancy certificate that says, here's your official registration of your trademark. So the critical pieces of doing this, and another reason why I think it's good to have a lawyer helping you through the process, is because they can tell you more or less what's going to fly and what isn't. Like if you wanted to file Apple for an Apple, no, that's not going to fly. But you want to select a name that's going to pass, and so pencil holder that's so generic. That's nothing that's going to pass. And I know you're going to say to me, who's going to think of that name anyway, because it's silly, but you get what I mean. And so you also want to select a name that, I mean, the more clever you are, the better off you are. But you also want to select the goods and the services. You want to select the proper class, because that can make a difference in the lane that you're in as far as confusingly similar. There are a total of 45 classes, and 34 are for goods and 11 are for services. And then, so they're different classes. Class 1 is for chemical goods. Class 41 is for entertainment services. So if you were doing Sylvie's songs, then you would use class 41 likely. So, and then for your own self, you don't want to use other people's, you don't want to infringe on other people's trademarks. So you don't want to use their trademark without their consent. And you don't want to use it for your own, like even on there, even you have to be careful in how you use it in your media and how you refer to Coca-Cola, for example, and, lifting their logo and putting it on your site. You probably would get a slap for that. So you don't want to do that. Oh, here, I do have this in here. The trick that I'm telling you to use before you register. So one thing people don't understand is, you see this TM symbol here, whoops, or the R. With the R with a circle, you see that on the Coca-Cola. Look, next time you see their logo, that means it's registered. The TM you can use anytime before you register. Even if you don't want to register, you can use that TM, or if it's a service, you would use the SM. But you can use that to just notify people that, like, look, I'm claiming this as my own name. And so it's an alert to the public, and it's also can help establish your common law right to use that mark, but you don't have to register to use that. And then again, the R is only after you get the registration certificate, not just because you registered doesn't mean, you can use the R. You have to wait to get it. But then once you get the registration, I helped this client register a trademark, and then she never used the R. And I kept writing to her and going, why are you not using the R? And she didn't want to change her graphics. I'm like, oh my gosh. Okay. Well, you just kind of blew that.
I never knew the difference between those two. I was always wondering what the difference was. Now I know.
Yeah. Now you know. You heard it here first. So per class, you can pay $225 to $325, and I think it's actually just gone up to $375. So usually there's a difference in the type of application, so it would depend on what it is that you're registering and how you're going to use it. And if you need some flexibility, you might have to pay $275 per class, but $225 per class works for a lot of people. But it can become quite complicated. So again, it's good to have an attorney. I think the other thing is, if you're ever planning on selling your business, a trademark, having your registered trademark is very valuable. So I think it's a great asset to have. And if you might have more than one. So a lot of people have a trademark portfolio in their business. And then you do have to, and people will pay money for registered trademarks because it again says you take your product or service seriously, and that you went through that extra step of protecting it so that there aren't imposters. Part of that is also that you want to have the monitoring it, and that's a whole another area that we could spend a lot of time on, but just policing, they call it policing your mark, but you want to monitor to make sure, and you want to have regular checks on, is somebody out there using it, and how are they using it? And do I need to have my lawyer write a cease and desist and all those kinds of things? So, but I think it adds value to your business to have a trademark, and it's an advantage, increases the value of your business if you sell. And so yeah, here's the trademark office. And if you go in there, there is the database you want to use is called TESS, TESS. And that's where you're going to search for any words that might be similar to what you're planning on using. Or there's a thing called a stylized mark, and that's if you're going to just trademark your logo and that's not words, then you have to search for a description, and that search gets a little more complicated. Fair use cases, that's more for copyright. So I would say not to, you don't have to spend a lot of time on those, but if you wanted to be reading up on some legal cases, there's a link there. If you want to work with me to help register your trademark, there's a link to my page. I charge a flat fee of $1,500, and then it's per class, whatever that is. So yeah, so that's what I have for now.
Thanks, Susan. We've actually got a couple of questions as well.
Yay, I love questions.
Is there a generic price for registering trademarks, or does it vary by state? Is the first one.
So it's a federal registration. If you want to, you can also, if you want to start out with, you want to take the next step above a common law trademark, and you want to have some protection, you can register in your state. If you register in your state, that gives you the protection in the state of Wisconsin, for example, but you have to follow their procedure and pay their registration fee. It does not give you protection on a national scale. That is with the U.S. Patent and Trademark Office, and that one's the same for everything. It's, the $225 to $375 per class. I can say in Minnesota, it's $50 to file a trademark application. So I encourage a lot of clients to do that, actually.
Okay, that's great. Thank you. And then, does using the TM symbol help prevent others from stealing ideas from you? Can you use that in court as evidence that you used the name before?
Yes, it is helpful to use it, because it does, as I said, it does put people on notice that you're staking a claim and how you use that. And you would use that as evidence in court. Yes, most certainly. And it helps establish your common law right in that.
Great.
I think there was another component to that question that I might not have answered.
Does it prevent others from stealing the idea from you?
Yeah. I don't know if it prevents, but I think it deters. I think, well, no, I think it does deter people from taking it. They know you took it seriously. It's the same with using the copyright symbol. I think we covered that in the last one, that, it's not legally required, but the reason to use it is so that people know, hey, this is mine. stay away.
Yeah. I have a question actually. If you're like an Australian business, can you register in the US if you're not a US business, or do you have to be a US business to have a trademark?
You can register in the US.
Yeah. Okay. That's
Happy
good.
to register for you.
We've had one more, which is, can you register a trademark without having a product? Say we are creating a company that sells goods, but we don't have the products yet. Can we apply for the trademark with the intent to sell a product?
Yep. So there is an intent to use. So typically when you register for a trademark, you're going to show, when you you submit the specimen, you're going to show how it's used in what they call interstate commerce. So it has to have been used. You have to have sold it across state lines. So if you're in Wisconsin, you have to sell your cheese to somebody in Illinois or Michigan or Minnesota or something like that. If you don't have anything, a product yet to apply it to, you can file an intent to use. And then in 6 months, you can get another extension. I think the current guidelines are you can extend it 3 times, so you can extend it up to 18 months, but then you have to convert it to a use in interstate commerce application.
Okay.
So it's a little more expensive, but if you think somebody else is going to use it, or you definitely want to make sure you have it and you're investing a lot of time and money, yes, do it.
That's interesting. So, but in the meantime, that they could use like the TM with the intent to register, and then
they should use the
later.
TM, and then yes, but they don't have a product to put it on, so where are you going to use it?
Great. Gabby says, thank you, it's very helpful.
Good.
If you've got any more questions, guys, then please ask them now. If you can't think of anything now and want to ask later, then as I said, you can always leave a comment on this video and we'll be checking back to get back to you.
Yeah, and there is so much more to trademarks. It's a little complex, but I just wanted to give you the basics so you don't have overwhelm, but just so you understand the framework of how it works.
Yeah, it's really helpful, and the links are great too. So we'll share a link to this presentation as well in the group. And if you do want to have a chat with Susan directly for your own personal circumstances, then her website is susanburnsllc.com. And you'll find some really great information there and her contact details. But Susan's a member of this group as well.
Yeah.
Luckily for us.
Hey. Oh, thanks.
Great. Well, I don't think there's any more questions at this point. I think it was really helpful and very thorough. So thanks for the overview into trademark, Susan.
Yes, you're welcome. My
chat.
absolute pleasure. Always a pleasure.
Awesome. Thanks for watching, everyone. Have a great day.
Thanks, everyone. Bye-bye.